Where I thought I'd probably start is just really a quick recap on the insolvency relief that's been put in place as a result of COVID. So back in March, the government quickly put some measures in place to try and protect businesses from insolvency. And largely those protections have assisted and enabled businesses to essentially hibernate through this really difficult period. Some of the relief that was put in place was an extension in terms of the time to comply with a statutory demand or a bankruptcy notice. Ordinarily, that was 21 days, which was pushed out to 6 months. So again, giving debtors a bit more breathing room to deal with their financial distress. And in addition to that, the amount upon which you could issue a stat demand or a bankruptcy notice was increased to $20,000, up from $2,000 for a corporate entity and up from $5,000 for an individual. So those assistance packages really help businesses avoid having to go into an insolvent regime. And in addition, the government put in some protection in relation to directors' relief in terms of insolvent trading. So if the director was incurring debt during this period, in the ordinary course of its business, then it could have a defence against any insolvent trading claim that might be brought by a liquidator later on. So those assistance packages, along with the other ones, such as the JobKeeper, and as Paul mentioned, in terms of the relief from landlords, really have assisted viable businesses to make it through and start to come out the other side. Now we're sort of coming out of our lockdowns, particularly in Victoria. There has, however, been some unintended consequences. And you may have heard in the news and the reports and on LinkedIn talking about zombie companies. Ordinarily, per annum, there's about 8,000 companies that are wound up. And during this period of COVID, pretty much since March, there's been very few wind-ups as a result of the relief that's been put in place. What that sort of means is that there's been a lot of companies that should have gone into liquidation or sort of some form of external administration that haven't, and are just surviving off JobKeeper and the like to keep ticking along. All things that are good must come to an end. So the relief that's in place at the moment in relation to the stat demands and the creditor enforcement, and also the insolvency relief, is coming to an end as of the 31st of December this year. It's a key point to note that in relation to the insolvent trading relief for directors, that the way the legislation has been drafted, and there's a couple of different views on this, but our position, or my position, is that the way the legislation has been drafted is that the defence to an insolvent trading claim as under the relief mechanism will only be available to a director that places their company into external administration by 31 December. So if they placed into external administration on 2nd of January, for instance, then they may not have that protection afforded to them in relation to an insolvent trading claim. And I expect that that's going to be something that would be tested through the courts in due course. As a result of this enforcement relief being lifted, we do expect there's going to be a significant spike in statutory demands and bankruptcy notices. I've been speaking with a number of debt collection agencies and lawyers around town, and they've sort of got them stacked up ready to go come 1 January. So there'll be obviously a bit of a delay with the court process and actually having the stat demands expire and so forth. But we do expect to see that bit of a spike in insolvency matters come on somewhere between sort of February, March, April or thereabouts. The government, however, has, in an effort to try and assist businesses to restructure and keep their businesses going, introduced significant changes to the insolvency laws, which have just recently passed in Federal Parliament. Those changes are to commence on 1 January. And essentially the key issues that the legislation deals with is what's called a small business restructure and also a streamlined liquidation. If you attended our last webinar where we had USA versus Australia and Chapter 11 versus a small business restructure, you would have heard Andrew Barnden of our New South Wales office, one of our partners there, going into a fair bit of detail around the processes that were proposed in relation to that small business restructure. Just to touch on that really quickly, the small business restructure is you're only eligible to enter that regime if you've got $1 million of actual debts, and so not contingent debts or less. The tax lodgements must be up to date. the employee entitlements that are due and payable must be paid. So if you've got accrued superannuation that hasn't been paid, that must be dealt with before you can enter into a small business restructure. One of the key things, and this is where we talked about in our last webinar, is that it is a debtor in possession model. So the company enters into a restructure phase. The directors or owners of the business maintain control through that period. So unlike a voluntary administration where control is handed over to the administrator, the directors continue to trade through that period. That in itself, in my mind, poses a few issues, and I'll touch on that in a moment. The purpose of this is to assist the SME market, and what the government has introduced in the legislation is that the practitioner who's appointed will indicate a fixed fee for actually undertaking this process. So that'll be another interesting thing to see. Once the restructure process starts, the company and the practitioner develop a plan, and they've got 20 business days to do that. There is the scope for a short extension if you satisfy certain criteria. Once that plan has been developed, that's issued to creditors, and then creditors have 15 days to vote on that proposal. One of the other key instances in relation to voting is that the related parties are excluded from voting. So it avoids creditors being stacked and those sort of deals being pushed through. The other key difference to a voluntary administration is the plan is accepted by a majority in value, whereas a voluntary administration or a deed is majority in value and number. And one of the other key things that, due to the way that the legislation has been rushed through, the company can declare its intention to restructure from the 1st of January. If it publishes an advert on the ASIC Public Notices website, is where we usually publish all our appointments in relation to insolvency appointments and so forth. If they do that, then they have the extension of the insolvent trading relief up until 31 March. So if they do it on 1st of January, they've got a 3-month window. If they do it on the 1st of March, they've only got a 31-day window. The streamlined liquidation was the other key piece of legislation that has been introduced. The issue with the streamlined liquidation, or the purpose of the streamlined liquidation rather, is to where there's a small, very simple company, reduce the investigative requirements and so forth, to again try and reduce costs for that market and get those assets, distressed assets, recycled and back out into the community, into the business community. There has been an issue identified in the legislation in terms of the time periods in which the process needs to take place. And the advice we've received is if a practitioner takes appointment as a liquidator for a streamlined liquidation, they will be breaking the law. So they're breaking the legislation as a result of the way it's been drafted. ARETA has been very vocal on this, and despite all the efforts from industry, and particularly ARETA, the legislation passed through Parliament unamended. So that'll obviously be a matter that the government will need to deal with in the new year. So what do companies do or businesses do in terms of if they're finding themselves in financial distress? First and foremost, and what we do here at Rogers Reedy is look at opportunities for a restructure or a turnaround for the business. We've got a sister entity, as Brent mentioned, Trafalgar Business Advisory, who specialises in that area, and which is a non-insolvency business. As soon as you hand a Rogers Reedy card, everyone knows Rogers Reedy as an insolvency business, and directors don't generally like to talk to liquidators. So what we try and do through that is work through potentially developing a safe harbour plan, restructuring debt, looking to negotiate with financiers, looking at potential additional income streams, and then sort of overall looking for opportunities to develop growth. I'm working on a matter at the moment where I'm assisting a business in the tourism industry, and they've run into really significant issues in terms of their income going from about $12 to $14 million a year to zero overnight as a result of COVID. So working through with them, developing a plan and assisting them to negotiate with their financiers in terms of getting through the other side. The formal alternatives, as most of you may have come across in the past, A voluntary administration is a great strategy in terms of if a restructure or informal process isn't going to work, then a voluntary administration takes the control away from the director who may have got the company into that position, and then the administrator can then conduct an investigation and work through what's in the best interest of creditors. There may be a proposal under a deed of company arrangement put up by either the directors, shareholders, or a third party, and the administrator will go through a process to assess whether creditors' interest would be best served by accepting that proposal, or otherwise the liquidation of the company. There's also prospects in terms of a voluntary administration that would then lead to a liquidation if the business itself isn't viable. That may also constitute or involve a sale of business, similar to what Brent mentioned earlier with the CS Logistics matter. However, that one went through a DOCR as well. The small business restructure, which I've already mentioned, or alternatively, if the business isn't viable and it can't be restructured, then liquidation and an orderly winding up of the company may be the most appropriate course of action. In liquidation, employees would be entitled to make a claim against the fair entitlement guarantee, so their employee entitlements can be dealt with. And really, again, dealing with the realisation of those assets and selling those assets and getting them out and getting the best return for creditors. So that's pretty much a quick overview based on the time I sort of had. Just wanted to note that, yeah, both at Rogers Radio, at all our offices around Australia, we definitely have the expertise and experience in relation to all the matters that I've talked about today. And what we really aim to do is help struggling businesses that are in financial distress get through the other side, so we can minimise the impact on all stakeholders, be that employees, business owners and creditors.